This is a video to overview the professional standards process. Professional standards deals with professionally based ethics-related complaints or arbitration requests involving active realtors of the association. What is the difference between ethics and arbitration? An ethics complaint charges a potential violation of one or more of the articles of the Code of Ethics. A request for arbitration asks the association to resolve a dispute between members with regard to the entitlement of a commission between brokerages. Many difficulties result from misunderstanding or lack of communication, so before actually filing a written complaint, try to contact the agent involved. If that provides no resolution, try to contact the responsible broker for the office. The professional standards process takes time and involves the filing of paperwork on your part. The association can only assist you in the process to file this paperwork. We are not able to file the paperwork on your behalf, provide legal advice, or advise if a particular issue is or is not a violation of the Code of Ethics or is a matter for arbitration. So who can file ethics complaints and who can file arbitration requests? Anyone can file an ethics complaint. However, arbitration requests usually involve a controversy over a commission. The broker of record of the agency requesting an arbitration must be the one to file a request and agreement to arbitrate. There is a $500 filing fee. Agents cannot file arbitration on behalf of the brokers. Ethics complaints overviews. An ethics complaint does not deal with monetary awards or compensations. If the issue involves the payment of money, an attorney should be consulted. Ethics complaints do not deal with the enforcement of the law. If the issue involves violation of a state, federal, or local law, the police or attorney general should be consulted. Ethics complaints do not deal with Florida real estate licensing law. If the issue involves violations concerning Florida real estate license law, the State of Florida's Department of Business and Professional Regulations should be consulted. A very important note: any complaint must be received within 180 days of the occurrence or within 180 days after the facts constituting the matter complained of were known, otherwise we cannot accept the complaint. So what is the complaint resolution process? What do you need to do now? Number one, the first step would be to call Sharon Hoytich at 239-936-3537, extension 234. Step number two, we need to determine the status of the member. Step number three, we need to determine what your goal is. Number four, we need to identify the path you will take. Will you be actually filing a complaint or using the services of an ombudsman? Step number five, we actually begin the process. So the paths to resolution are two. Number one, you would call the office and request a packet to actually file the ethics complaint or the arbitration request. Or number two, call the office and be assigned an ombudsman representative. How do you know if you wish to use the services of an ombudsman or not? The Ombudsman Program was developed by NAR and works to anticipate, identify, and resolve misunderstandings before the matter actually escalates into a possible charge of unethical conduct. The Ombudsman helps determine, through discussions, if the misunderstanding can be resolved. These services are available to you free of charge, and they will help you informally resolve your issues. These services can be declined at any time so that you can move forward to directly filing a written ethics complaint. Here is a look at the step-by-step process. Number one, call the association at 239-936-3537, extension 234. Request a packet for the paperwork. Number two, complete the packet and return it to the association. Upon receipt, a file is started and a copy of the complaint is mailed out to the respondent. Number three, the respondent has 15 days from the date of receipt to reply. Once the reply is received, the file is copied and forwarded to the grievance committee for review. Number four, The Grievance Committee meets the last Tuesday of each month. The role of the Grievance Committee is to act like a grand jury and determine if there is enough factual information presented to support the claim that an alleged violation has taken place, or if there warrants a review of procuring cause. The Grievance Committee determines if the case should be forwarded on for a professional standards hearing or not. Number 5. If the facts warrant, the case will be forwarded on for a professional standards hearing. The purpose of the hearing is to determine if the violation of one or more of the articles within the Code of Ethics actually occurred, or if a case for procuring cause actually needs to be reviewed. Otherwise, the case is dismissed. Number 6. If a violation has occurred, the hearing panel will recommend disciplinary action against the respondent. Possible disciplinary actions for a Code of Ethics violation could include a letter of warning, a letter of reprimand, requirement to attend some sort of continuing education class, and/or appropriate and reasonable fine. If procuring cause has been established, the panel will determine the commission dispute accordingly with regards to arbitration. In summary, here is what you would be looking at to do. Number 1, call to discuss your issues and options. Number 2, determine what you would like to do. Number 3, choose your path to resolution. And number 4, complete the necessary documents. There is also some additional information available for you. Unlicensed real estate activity is reported to the state of Florida at 407-481-5662. Unlicensed real estate activity is a third-degree felony in the state of Florida and would result in a fine of up to $5,000 and a jail sentence of up to 5 years. Any escrow issues should be directed to the Florida Real Estate Commission. The escrow division can be reached at 850-487-1395. Legal advice. We are not able to provide legal advice. You would need to call the Florida Association of Realtors Legal Hotline, which is a member service provided to you free of charge. They can be reached at 407-438-1409. Non-payment of commission from a broker, current or past, to an agent or independent contractor after the agent leaves the company. This does not fall under ethics or arbitration. An independent contractor agreement is a legal and binding document that should be signed by both you and your broker. You should carefully review the document before you sign it to make sure you understand each and every provision. The provisions of this written independent contractor agreement will determine the legal and contractual relationship that covers any commission's disputes after you leave the organization. Thank you.